May it please the Court, Chief Justice, I appear together with Mr. Seri for the applicant for leave, in the application for leave to appeal.
May it please you, Chief Justice and members of the Court, I appear for the respondent together with my learned friend, Mr. Davis.
Thank you, Mr. Mobu. Right. You may proceed.
The applicants approach this court seeking leave to appeal, together with condonation for the short delay in lodging the application. And if both are granted, they ask that the appeal be upheld, the order of the LAC be set aside, and the judgment of the Labour Court confirming jurisdiction in the unfair dismissal dispute be restored. The key question we suggest before the Court is whether Section 189A7B2 of the Labour Relations Act creates a bespoke path directly to the Labour Court once the facilitation process has failed and is followed by a decision by the employer to dismiss. Put differently, does facilitation by a CCMA-appointed facilitator over 60 days in up to 4 meetings and conducted by someone skilled in conciliation, mediation, facilitation, does that substitute for conciliation on a proper interpretation, so that a valid referral to the Labour Court may be made within 90 days of the decision to dismiss? What we say the case is about is whether Parliament deliberately created facilitation as a substitute for conciliation, opening a direct election, strike or court, without the need for further conciliation in either instance. And we submit that Section 189.7b2 does just that. It provides a direct route to the Labour Court, just as it provides a direct route to... We say the policy choice is implicit in the section. Read fairly, we submit the text allows for that meaning, despite its awkward cross-referencing, and that it is an interpretation that makes sense. It's efficient, it avoids pointless duplication, it honours the purpose of the statute, and it gives, above all, it gives effect to the constitutional rights in sections 23(1) and 34. And we say that that's the interpretation the Court should adopt. When Parliament introduced Section 189A in 2002, it made 2 important innovations for large-scale retrenchments. In the first place, it created what was then a brand new right to strike, following notice of termination for operational reasons. So you now had a right to strike, which you didn't have before. And secondly, it introduced facilitation. This is a structured process, formalized third-party intervention over a period of 60 days, up to 4 meetings, conducted by a CCMA-appointed facilitator, skilled in conciliation, mediation, and facilitation. And what is clear is that Parliament made a deliberate policy choice, certainly in the strike context, where facilitation would be the substitute for conciliation. So in a strike, facilitation substitutes for conciliation. The right to refer an unfair dismissal dispute to the Labour Court was retained, and the central question is whether Section 189A7B2 of the Labour Relations Act, which provides for litigation route as an alternative to strike action where there has been facilitation and the 60 days have elapsed, operates in the same way that the right to strike does in the subsection. We say it must. If facilitation substitutes for conciliation in the case of strike action, there's no obvious reason why it shouldn't do so in the case of litigation. And as will be developed in argument, The text of the statute, we say, is capable of supporting the applicant's interpretation when read in the context of the section, the Act as a whole and its purpose. The interpretation, we say, is plausible. It achieves a sensible and businesslike outcome. It's less costly, it's more efficient, avoids what would probably be an unnecessary duplication, or at least a further 30 days additional delay. It also ensures parity. Employees who elect to strike after a failed conciliation are treated no differently from those who elect to take the litigation path. And we say that that distinction, that there's no reason to draw that distinction. In relation briefly to the jurisdiction of this court, this court, we submit, has jurisdiction as it raises a constitutional matter, as envisaged by Section 1673B, Little Roman 1 of the Constitution. It involves the interpretation of the Labour Relations Act, the right to fair labour practices under Section 23(1), right of access to the Labour Court within the ambit of Section 34 of the Constitution. It also raises arguable points of law of general public importance, which ought to be considered by the Constitutional Court. It's in the interests of justice for the legal question to be finally determined, as it concerns the rights of employees and their trade unions in the context of large-scale retrenchments. And also, vitally important in this context, and why it should be heard by the court, is that if the LAC judgment is correct, then very many judgments of the Labour Court were delivered by a court lacking jurisdiction, and they're void. So it's a very important question. Just briefly, I'll deal with the question of condonation. There was a 15-day delay. The explanations provided in the record, paragraph 72, 73, pages 34 to page 35, an explanation there we submit is understandable. There were no periods of inaction. The question's nationally important. There are, we submit, prospects of success, and there's no prejudice. Respondents face no forensic disadvantage at all, and it's in the interest of justice for the conflicting lines of authority to be resolved and to stabilise practice in large-scale retrenchment dismissal cases. So we submit that condonation should be granted. All right, then let's turn to the text. And within section 189A7B2, we say there's an internal conflict. On the one hand, the section expressly confers a right to refer a dispute concerning whether there's a fair reason for a dismissal to the Labour Court. Yet in the same breath, it says that must be done in terms of section 191, subsection 11. This is a provision which forms part of a different process and whose function in the scheme of section 191 is simply to fix the period within which the Labour Court referral must be made. If this means that the jurisdictional facts that are mentioned in section 191.11 are incorporated into section 1897B2, then the first part of the section grants a right to refer the dispute to the Labour Court, but then simultaneously takes it away in the second part. We contend that that conflict should be resolved in favour of an interpretation that gives real content to the right and not one that actually defeats it. The equivalent subsection to section 189A7B2 in the process and part of the scheme in section 191 is subsection 191(5)B, Little Roman 2. The jurisdictional fact for a referral under section 191, the if part of the section, is a referral for conciliation, and if the and the failure of conciliation and the lapse of 30 days, or the lapse of 30 days. So under 191, the jurisdictional fact is a referral for conciliation and either its failure or the passing of 30 days. And we submit that that should be contrasted to the ifs part and the jurisdictional fact part of section 189A7B2. It identifies a different set of jurisdictional facts. There, a facilitator has to have been appointed and 60 days have elapsed from the date of the section 1893 notice, and an employer must have given notice to terminate the contracts of employment. We submit these are two distinct jurisdictional gateways, and to conflate them is to distort the statutory scheme. Section 191.11's only function within section 191, and the structure of that section, is to provide a period within which a referral of a dispute to the Labour Court must be made. In terms of section 1915B, i.e. a dispute of the kind that in terms of the court, but 191.11 simply deals with time, with the period. So the question arises then, does the phrase, quote, in terms of section 191.11, unquote, have the same function when it's used in section 189.7b2, namely simply as a timing provision, to be read mutatis mutandis in relation to a referral made under section 189A7b2. A section 198A7b2 referral is not a 1915B referral, because when the right ostensibly arises and accrues under 189A7b2, no corresponding right is accrued under section 1915B. On reading the reference as dealing with timing, the 90-day period would sensibly run from the date of the notice of dismissal described in section 189A7A, exactly as the Minister understood it when issuing the regulations, and much the same way as the Labour Court judges in general dealing with the matter had understood it in Edcon. That's what the applicants contend for. We say it's a construction that's sensible, practical, and neat. Or, the other side of the coin, does it instead import the jurisdictional facts that must exist under section 195B before the referral can be made under 191.11? That interpretation is obviously textually possible, as we see from the judgments that find that to be so, but we submit it produces anomalies, and anomalies that should be avoided. Firstly, if 1915B must come into play, then the reference to Labour Court in the sub 7B2 is not only misleading, but it's wrong, because at that stage there's no accrued right to refer. In fact, on that interpretation, it's legally impossible to refer the dispute to the Labour Court, since the necessary jurisdictional facts do not exist. Very much as the applicants found in this case, in the judgment in the Labour Appeal Court. And we submit that Parliament couldn't have intended to create a statutory right that cannot be exercised, a right that collapses at the moment it's invoked. Such an outcome, we submit, is absurd, and it underscores why the applicant's interpretation should be preferred. Then the other feature in relation to the text is that the interpretation that section 191.11 incorporates the jurisdictional facts under section 1915B is that it distorts the meaning and purpose of section 191.11 in the context of section 191. It has a specific purpose under that section, which is timing, and we're using that same section to give it an entirely different meaning and role. It stretches the section beyond its originally intended role by requiring that the jurisdictional facts necessary for 191 to operate must also be met before section 19111 can come into play when applied in the present context. But that section was never designed to carry that burden. Reading it in this way assigns an entirely new and expanded role, a role that sits uneasily with the first part of the section of 189A7B2, which on its face we suggest confers a right to refer the dispute directly to the Labour Court. So the change of role is another relevant feature in the interpretation. And then thirdly, we say that the respondent's interpretation is a highly convoluted way of saying nothing more than this. If strike action is not chosen, the union and dismissed employees retain the same rights to refer a dispute to the CCMA as they had before the amendment. That makes the subsection redundant. It's misleading, essentially meaningless. Worse still, on this interpretation, there's in fact no right to refer under section 19111 at all, because such a referral, like the one in this case, would be stillborn, the necessary jurisdictional facts being absent. So why then would Parliament confer what appears to be a right to refer a dispute to the Labour Court only for the latter part of the section to destroy that right and to turn it into nothing more than a mirage? And then there's the further question that one could ask. If there's a referral to the CCMA under section 191 after a failed facilitation, because that's what referred in terms of section 19111 means, is that one contemplated by section 1897B2? If so, do the parties at that point lose their right to strike? Or was the forfeiture of the right to strike only triggered after a failed conciliation and an election later to proceed to the Labour Court? These uncertainties, we submit, highlight the need for an interpretation which is coherent, consistent, clear, and we say that the interpretation we advance, permitting a direct referral where there's been a facilitation, avoids that uncertainty altogether. We, of course, accept, well, we say that the text, both interpretations are arguable. But which interpretation is correct must be resolved through a proper interpretive exercise, one that considers context and purpose, and one that achieves a sensible, business-like, cost-effective, and efficient result. And we say that the interpretation advanced by the applicants does that and the alternative does not. An interpretation should avoid unfair differentiation based on the election made as to whether to strike or litigate. Employees who choose to strike are not subject to further procedural hurdles. That's expressly set out and a clear policy distinction made in the Act in relation to that very subsection. So there's no obvious reason why employees choosing adjudication should be treated differently. And we submit that an interpretation that creates unfair differentiation should be avoided. An interpretation, of course, should also, as far as possible, promote rights guaranteed in sections 23(1) and 34 of the Constitution. In this context, those rights militate strongly against an interpretation that bars employees from direct access to the Labour Court and that unnecessarily prolongs the resolution of an unfair dismissal dispute. And then the question is, and the central question really is, was it intended for facilitation to substitute for conciliation? And we say facilitation shares many of the features of conciliation, but of course there are differences, which we acknowledge, but we say they shouldn't be overstated. once a facilitation process whose very purpose is to avoid jobs and to achieve an outcome that is fair, if people are dismissed following that process, has failed. That was the whole purpose of the process, and if it's failed, de facto, we say, there's very little more that a conciliation could add that would meaningfully affect the decision to terminate. The job's already been done, in fact. One can find differences and academically point to them and philosophically say, well, it's a different dispute now, so therefore it's different. But we submit at a practical level, de facto, there really is no point in it. And that is made clear by the legislation itself, because it was a deliberate policy choice that where employees elect to strike, facilitation is treated as having served the purpose of conciliation with no further referral required under section 64(1)(a). So it applies in relation to strike. It's a more robust, more disruptive process. It's considered as adequate and a replacement for conciliation. And we say that the same logic should apply to the parallel election to litigate under section 189A2B2. And reading this provision consistently achieves the cost-effective, sensible outcome, avoids the duplication that we submit is unnecessary. And we point out that both are housed in the same subsection next to each other and are expressed as alternative parts of the same of an election that has to be made, which also points to it being sensible and practical, and what was intended, that both should have the same feature of facilitation substituting for conciliation. Reliance was placed on the intervalve case in this court, but we say that that cannot provide an answer to the interpretation question that's currently before the court. It's obviously true that if the reference in section 1897B2 to section 19111 incorporates 1915B, then intervalve is decisive. If it incorporates it, then there has to be a conciliation. But that doesn't resolve the question of whether that is what it does and whether it substitutes facilitation for conciliation. And that is the question that has to be decided by this court. If the correct interpretation, if the same policy choices that applied in the case of strike action applies equally to an election to litigate, namely that facilitation suffices without a further referral, facilitation suffices without a further referral to conciliation, then intervalve is with respect irrelevant to that question. It certainly cannot resolve that issue, and what intervalve held was not that conciliation is indispensable, but rather that under the structure of section 191, jurisdiction of the labour court requires a referral to conciliation, and either a failed conciliation or an expiry of 30 days. So it's really a referral and a period, and not an actual conciliation. That is absolutely essential. And so, in closing, I just say the following. This case is about giving proper effect to Parliament's deliberate policy choice in section 189A. The legislator created a process of facilitation conducted by a person skilled in conciliation, mediation, and facilitation, and was intended to take the place of conciliation where large-scale retrenchments are at stake. Employees are then given a simple election to strike or to litigate. Both routes rest on the same foundation. There's no rational basis we submit for treating one differently from the other, or for coming to the conclusion that the lack of a need for conciliation because facilitation is sufficient in the one should be dealt with differently in the other. We say that the interpretation of the Labour Appeal Court empties subsection 189AB72 of meaning. It renders it redundant, misleading, trap for the unwary. It forces parties back to the CCMA for a process that has de facto already occurred under a different name, producing duplication, delay, cost. And we say that that interpretation undermines efficiency, fairness, and certainty that the Act was meant to achieve. And by contrast, the applicant's interpretation, we say, is not only textually plausible, but also consistent with the structure of the Act as a whole, with the constitutional rights to fair labour practices, access to the courts, and with a clear legislative intention to streamline disputes arising from mass retrenchments. It provides a coherent, business-like, cost-effective outcome and avoids absurdity and respects the purposes of the statute. For these reasons, we respectfully submit that condemnation should be granted, so too leave to appeal, and then we ask that the appeal should be upheld, the order of the Labour Court set aside, and the judgment of the Labour Court restored, and we say that there should be no order as to costs. Thank you, Chief Justice. Just within 30 minutes.
Thank you, Mr. Peterman. Right on the dot. If facilitation is different from conciliation, and they are both beneficial processes meant to serve different purposes at different stages of this process, facilitation being brought in before dismissal to assist the parties to reach agreement and hopefully save jobs, and conciliation after dismissal to ensure the fairness of the dismissal. Why should we regard conciliation as a duplication, an unnecessary duplication, as you call it, which you have labeled in many negative ways?
Well, there are two answers to that. The first is, we submit that de facto, what happens during the facilitation process, we accept it's a different process. It's a process that leads up to the dismissal. It's not a process that follows the dismissal, as conciliation would certainly, if the interpretation given by the LAC applies in this context. They're different processes, but we submit that de facto, if what you're seeking is to achieve fairness in a dismissal, alternatively avoid dismissals, you've canvassed the ground, you've covered all that ground, and when the legislature decides in its wisdom to make a policy choice and say, where there's facilitation, you don't need conciliation in the strike context, which is much more disruptive and a process than going by way of litigation. One must look at it in that context and say, well, it essentially serves the same purpose. It's recognized in the one, and we say it's implicit that it should be recognized in the other, acknowledging the differences that are put to me. But we submit that in that context, what it does is it creates an extra hurdle, it creates an additional, probably pointless exercise, even though notionally it would be an exercise to argue about the fairness of the dismissals, but that question has already been dealt with through the facilitation consultation process, which is its whole purpose. So that's why we're saying it's a duplication in practice. It's not de lege a duplication because of the differences that you put to me, but in practice it is, and on a proper interpretation, if it's excluded in relation to the one, it should also be excluded in relation to the other, because it's really pointless.
And why would the legislature have bothered to create this elaborate chain of cross-referencing from 189A 7B to 191.11, 191.5B?
Very, very strange draftsmanship, but on either basis. The one, my learned friend does that lovely picture in his heads where he crosses things out and he adds things in and says, well, look at this, you're really destroying the language. But you could do the other side, you could cross it out and cross out Labour Court, which is the main point of the text, is that you have a right to go to the Labour Court. Yes, in terms of 191.11, but you have a right to go to the Labour Court. And if in terms of 191.11 means you don't have that right at all, because the jurisdictional facts necessary for you to get there aren't in existence, then it's giving you a right to go to the court when, as happened in this case, the court should have found, according to the LAC, that it had no jurisdiction. So it's a pointless referral to the Labour Court, and one shouldn't interpret that to give the substantive right should be preferred rather than the incorporation by reference under section 191.11, which is designed to deal with a different process and deals with that process to incorporate that reference to the process that gets you there, as if you have to now start again and go through that process. So that's our submission.
Mr. Pilema, just a follow-up on your debate with the Chief Justice. What is the real objective of a facilitation process?
To achieve a just and fair consultation process that achieves a just and fair outcome. There are going to be dismissals where retrenchment requires them, but it should be done fairly. And one should try and minimize the number of dismissals. That process, that consultation process, is designed to achieve that outcome. And
then after dismissals?
After dismissals, it means...
Let's say there's merit. Let's just accept for a while that there's merit in the submission, that there's different purposes of facilitation and conciliation, and that it would be beneficial to go through the conciliation process. What happens at conciliation? After it has been clear that the facilitation process has not succeeded.
Yes.
And that there could be dismissals.
I would suggest in the overwhelming number of cases what would happen is either they'd wait the 30 days or there'd be a meeting and parties would say, well, we've exhausted our positions, everyone knows where we stand, we need to follow this process through. Why would there be a whole change of heart?
I'm asking, that's why I said, let's debate this as if we're accepting what the respondent is saying.
Yes.
That conciliation is necessary. So I'm asking you, what usually happens at conciliation? Would it be the same? Would it the same what happened? Would the same thing that happened at facilitation happen at conciliation?
Well, at conciliation, you would have a person skilled in conciliation, meeting with the parties if they have the meeting.
But conciliating what? What would be the...
Well, the allegedly unfair dismissal. So what you would have is a dismissal, well, what you have is a dismissal that occurs, or notice of a dismissal. You can refer it immediately. There is notice of a dismissal under section 1912 capital A. But you refer that, and then you debate whether the dismissal or proposed dismissal is fair.
Yeah, sorry for the interruption. I just want to get to no, to the real distinction, if there's any, what is really discussed there? You did say that when the parties enter the facilitation process, they are discussing means or ways of avoiding the dismissals through operational requirements.
That's the one thing, yes.
Yes. Now, the dismissals, it's inevitable, they've happened. What then is discussed at conciliation?
What ought to have also been discussed during conciliation was how to achieve the dismissals that are inevitable fairly, in relation to severance, in relation to alternative, in relation to various things. And you exhaust that exercise and it fails, and there's a dismissal, but there's still a dispute about the fairness. Then you would go to conciliation to talk about exactly the same things that you couldn't agree upon before. It is practically, de facto, a duplication. Not philosophically, because it's correct that the one comes after the other and the processes are notionally different. But what you're trying to achieve in the one is what you're dealing with in the other. And the two, to substitute the one for the other is not, what is there such a word as insensible, but it's sensible to substitute the one for the other. It's a newly created mechanism. It is substituted for the other in relation to the more disruptive strike situation. And we submit there's no apparent reason to now require the extra conciliation that's probably going to achieve no purpose. And then we have section 1574C. That's a section that allows a court, where it feels that conciliation is necessary and the matter hasn't been conciliated, to refuse the matter and require it to be conciliated. So in a case I can't imagine, if the direct access without a conciliation is considered by the court to somehow require a conciliation, it's always open to the court to do so. But that's not a jurisdictional question. The question here we're dealing with is whether or not the matter could ever get to the court, and we submit it does via this route on our interpretation.
You may have, thank you, Mr. Pilima. You may have covered what I'm going to ask, but maybe I didn't, follow it. Is there any significance to the fact that the section does not refer to 1915, but refers to 19111?
Well, we submit a whole lot turns on that. The significance is this, that 1915, within the structure of 19111, in 191 itself, is the jurisdictional fact that allows the further step to be taken under 19111 to refer it, and the time for refer under 1915, and then 11 comes in, giving you the date to refer it. The jurisdictional fact, we say, in a facilitation process is to be found in section 189A7B2, which is the equivalent, in a way, of section 1915B, in that it deals with what needs to be present before you can get to the court. So we submit it is relevant. That it doesn't, if the intention is to incorporate the whole section 191 process, then it really should have just not had the sub 11. It just should have said under 191. And it shouldn't refer to Labour Court, can process the dispute under section 191, because referring to the Labour Court detracts from that meaning, referring to subsection 11 in our submission detracts from that meaning, and gives rise to the possibility of the interpretation we argue for, and then we say that that interpretation is the sensible interpretation to be preferred.
Thank you. Thank you.
Mr. You haven't referred to the contrast or the fact that the lawmaker chose to deal with the case of a facilitation and the absence of facilitation in two different subsections. And in subsection 8, where it says if a facilitator is not appointed, then B says once the periods mentioned in 64(1)A have elapsed, there's the right to terminate, the right to strike, the right to refer to the Labour Court. Now, the periods referred to in section 64(1)A says requires that the issue in dispute should have been referred to the council and that there should have been either a certificate of non-resolution or 30 days should have expired.
Yeah.
So it seems to me that in the context of subsection 8, section 64(1)A would be the equivalent of section 191(5). It's the requirement to go to conciliation and have 30 days expire.
You know, yeah, sorry.
And that's in the position where there hasn't been a facilitator. Is it significant that that same phrase, once the periods in 64(1)A have elapsed, do not feature at all in subsection 7?
The section 8 covers the situation where there's no facilitation. Yeah. Under 11, where there's no facilitation, section 64 is applicable, 64(1)A is applicable,
Indeed.
Whereas it's not applicable under a situation where there is facilitation. So subsection 8 incorporates a need for conciliation under section 64(1)A, as you put to me.
It does so with reference to a time period. It doesn't say the right to strike. Although it refers to 64(1)A, it's not doing so specifically in relation to the right to strike. It's simply saying 30 days after the dispute has been referred to conciliation unsuccessfully.
Yes, and what was with respect was put to me was that that's the equivalent of a 1915B
Yeah.
Referral. In a sense, of course, that's correct, but not completely, because you have no right at that stage to refer a 191 referral to the council. So what section 189AB does, it gives you that right to refer it to a council, and that same period that would apply in both is completed, then you have the right. So you go through a conciliation or you refer it and the period passes, and you're entitled then to take the further step, either to strike or to refer it to the Labour Court. But there, you would have already been to the council, and that's why some of the earlier judgments said it's absurd to have to go for conciliation and then on the same wording as in 7, again have to go for conciliation a second time.
Well, under subsection 8, where there hasn't been a facilitator, as I understand it, because 8B requires the period in 64(1)A to have elapsed, you will have had to have referred that dispute to conciliation, and
Yes.
30 days will have expired.
Yes.
And if that has occurred, then the workers have two rights, either to strike or to refer the matter to the Labour Court.
Yes.
Now, it struck me as potentially significant that the phrase, once the periods mentioned in 64(1)A have elapsed, doesn't feature in subsection 7. In other words, neither in regard to striking nor in regard to referring to the Labour Court does it say that the periods in 64(1)A must have expired.
Yes.
Am I missing something?
No, well,
Is that of potential significance?
That would suggest that it doesn't apply in the earlier section, because in the earlier section, you've got facilitation as the process. In 8, where there's no facilitation, you have to have conciliation as the process, or the period expiring. But you have to go through the process of applying for conciliation and the period having expired, probably with a conciliation. So you do have a conciliation under 8, and then you can't have to have a second conciliation. Well, maybe you do, but our submission is that if that's what it means, it's totally absurd.
I mean, if subsection 8 requires two lots of conciliation.
Conciliations, one after the other, it's completely absurd. And facilitation, having served the same purpose, inverted commas, under 7 as conciliation does under 8, that's why it substitutes. So there is something to be drawn from that comparison. But you're right, I never dealt with it in the oral address.
You see, it also strikes me that the very fact that the lawmaker has chosen to deal with this in two different subsections has some significance. Because on the interpretation that the LAC adopted in this case, there's in fact no difference between the two scenarios with the limited exception of the right to strike.
Yes.
Everything is the same except for some reason on the LAC's interpretation, one doesn't need to have a conciliation before you can strike in the case where there has been a facilitator. But otherwise, the two procedures are exactly the same.
Yes.
Yes, thank you.
Mr. Pillemer, the section under discussion refers in terms to section 191 sub 11. Now, the respondents make the point, and I'd like your comment on this. The respondents say that if your interpretation is correct, then the section 191.11 would read thus: the referral, then in terms of subsection 5b, would fall away. Of a dispute to the labor court for adjudication must be made within 90 days after, and then all the words from the council until the dispute remains resolved. The employee or trade union has been served with a notice of termination. That's radical interpretive surgery.
Yeah.
And it concerns me because we are, in effect, completely redrafting the section on your interpretation.
Yeah.
Now, why would the legislature refer to section 191.11 in terms and then ask us to, in fact, interpret it in this fashion?
Well, the other side of the coin, why I refer to the Labour Court when, if you go under section 191.11, you can't get there. So it's this inherent contradiction within that section. If you're going under 189A 7B2, you've got a right to go to the Labour Court, it says. But if 191.11 incorporates the 191 process, by necessary implication, in other words, not struck out, then what that means is that you actually have no right to go to the Labour Court, as my clients found out in this case, because they went to the Labour Court and the Labour Court had no jurisdiction. So the question really is, does facilitation substitute for conciliation? If it does, then the surgery that's there is necessary. If it doesn't, then I would suggest it should be surgery the other side. You should cross out Labour Court and put something else. But that's the inherent contradiction, and we submit that both of those are arguable. Both of those can be correct, and the question is whether, on our case, is that radical surgery actually what the section means? We submit it is. But as my learned friends have argued, demonstrated with their lines, and as put to me, obviously it does involve reading in, and it involves crossing out of section 191.11, giving it its purpose of setting a timeline, which is its exact purpose under 191. So it's saying that that section bears the same purpose, and unfortunately, in the way the cross-reference is, it's awkward, and it doesn't anymore serve that purpose if it has that interpretation for which they contend, because it actually undermines the right.
As I read your submissions, you accept there's a distinct difference between facilitation and conciliation.
Well, there's an obvious difference. There isn't. Yeah, there's certainly a difference.
But this seems to collapse the two into one, that the facilitation and conciliation almost becomes one in your argument.
No, it doesn't with respect. It doesn't with respect, Justice Majid. What we're saying is facilitation substitutes for conciliation in that section in relation to strike. And then we say, well, why shouldn't it substitute for conciliation in relation to the second part of that election element, a referral to the Labour Court? And we say why it does apply is because facilitation de facto, having regard to what you're dealing with in the facilitation, to immediately thereafter deal with the exact same question, albeit in a different forum and under a different notional different process, is in fact much the same. And that's what we're saying. So we're not collapsing one into the other, we're saying the one substitutes for the other.
As I read Edcon, the Edcon judgment, what you're relying on appears to me to be obiter dictum. It wasn't necessary for the court to make those observations.
I think we can see that with respect, Justice Majid. But bear in mind that Edcon was a specially convened court. It was the Labour Appeal Court sitting as a court of first instance, mentioned a few times in the judgment as a very unusual process. It was because there was a judgment of the Labour Appeal Court that had been criticised and it needed to be revisited. And part of that process, the learned appeal justices in that court said it's appropriate and proper to set out the structure of the Act and explain exactly how it works. And it deals with the sections. It was focused largely on subsection 8 rather than 7, but in two places in the judgment and one place in relation to reasoning of what subsection 8 means, it makes it clear that in the mind of the court, there was facilitation substituted for conciliation, that there was no need for conciliation. So, of course, it is obiter and certainly would never be binding on this court. And the Labour Appeal Court was entitled to treat it as obiter, as it did. But we submit that it does lend some support to our argument in the sense that the minister in his regulations said that it had this meaning. It was the practical, sensible, obvious meaning with respect. The Labour Appeal Court, looking at it, dealing with it carefully, they said extensive heads of argument were presented by all the parties. It was a big case. Looking at it carefully, came to the same conclusion. So in its mind, it also thought this was the sensible argument, a sensible interpretation, and applied it. I agree. It's obiter, it's not binding, and it isn't fully reasoned in that judgment. It's a matter that needs to be reasoned again in this court, and it was reasoned, of course, in the Labour.
When all is said and done, it seems to me that as important as the case may have been, it's nothing more than a passing opinion
Yes.
made. For instance, that was not necessary for adjudication of the case.
Yes, I agree with that, and I agree also that the regulations can provide no valuable input in relation to the interpretation question.
Mr. Plummer, just the last aspect on the reading in or the reading out, and you've debated it with some of my colleagues. Wouldn't it be contrary to the principle of interpretation that the legislature doesn't use words in vain? The construction that the applicants would like us to put on the section would effectively require us to ignore large parts of section 19111, including the reference to subsection 5B and the reference to the certification of a dispute as unresolved.
Yes, that's the interpretation we suggest. The reference to section 5B isn't a reference to apply 5B. It just says in that section that it's a referral in terms of 5B. Let's just get the exact wording.
It says, I'm more concerned about the principle of interpretation.
No, I accept that on that.
And why should we not follow that principle in this case?
We submit not. We submit that applying the interpretive principles, that's of course a feature, and a feature that might militate quite strongly against the argument we advance. We accept that. But we say that it also, if that's the interpretation, then it plays down and gives the section no real meaning at all, and is misleading because it refers to labour court when you've got no right to refer it to the labour court. So it's a question of interpretation where, in this case, we submit that sort of exercise is appropriate. I agree with what's put to me that often that will not be, that as part of the interpretation process, every word should be given a meaning and so on. But we're saying that the purpose of 11 is to fix a time, and you should give it the same purpose. And if you do that, you've got to do this surgery, as was put to me. But yes, I understand the point, I accept it, but I submit that there's an answer to it.
Now, one of the other arguments advanced on behalf of the applicants is that there is no rational reason that in terms of section 189A7B1, conciliation would not be required prior to embarking on a strike, while conciliation would be required before referring a dispute to the labor court. Isn't it possible that one of the logical reasons for the legislature to distinguish between the right to strike and the right to refer a dispute to the labor court is that the right to strike is much more time dependent? When a retrenchment has already happened and requiring conciliation, it would almost wipe out the right.
With respect not. The right to strike would be a workforce strike. It wouldn't be dismissed people striking. And the right to a pretty useless strike if you're the target of a dismissal and you're unhappy about your dismissal and you say, well, now I'm going on strike, the employer says, okay. There's no point in that strike. So the strike is a strike by the...
Isn't there a different urgency in the two situations?
Yes, there is. There's an urgency in the... And the act in a sense you have to do the other things, and what it also says is that in that context facilitation substitutes. So now one has to say to ourselves, well, in that context it substitutes. Why does it not substitute in the other half of this election? You've got two parts of an election in the same section. Why does the one substitute, and where's the sense in not substituting the other? There are differences, of course, between strike and conciliation. But in that context, in the same section, parts of the same subsection, the one an alternative to the other, to give the one a particular meaning and the other a different meaning, differentiates, we say, unreasonably, inappropriately.
Yes. There's also been some discussion about the similar language used in 189A8B2 double B.
Yes.
Is it possible to have a reading of section 189A8 that the process prescribed where there's no facilitator might include a conciliation process before retrenchment, but also might not include such a conciliation? Seems to me that on the applicant's interpretation, it's possible that a section 189A8 process could be followed by a referral to the labor court without there having been either facilitation or conciliation. And how can such an interpretation be in line with the purpose of the legislator?
With respect, that interpretation is not possible on the section because the section requires the period referred to in 64.1a to expire, and 64.1a requires a referral to conciliation. So, yes, there would be a conciliation, but it would be under Section 189.
Is that not
8.
possible on the applicant's interpretation? That a Section 189A8 process could be followed by a referral to the Labour Court without there having been facilitation or conciliation?
No, we don't advance that at all. We say under 189A8, there has to be a conciliation by reason of the reference to 64.1. It won't be a 195 conciliation at the early stage. It might be one later, but there has to be that conciliation, that period before. So there has to be a conciliation. And if, as I, in my answer to Mr. Justice Rogers, if there is a conciliation before, it makes no sense whatsoever to have yet another conciliation immediately afterwards, even though notionally the causa has changed. And that lends support for our interpretation.
If I understand the applicant's argument in respect of this court's judgment in intervalve, I understand that the applicant seeks to distinguish that matter by saying that that case did not deal with the Section 189A large-scale retrenchment. But I don't see how we can get away from the principle that's established in interval, that conciliation is a prerequisite for the Labour Court's jurisdiction.
Conciliation isn't, with respect. What that judgment says is a referral to conciliation is, and then either a failed conciliation or 30 days. So the key is the referral to conciliation. That's the trigger, and then a passage of time or a failed conciliation. That's what the judgment says in relation to Section 191 and interprets Section 191, and on that interpretation, the jurisdictional facts that give rise to 195, of course, are applicable. But if the question that we're asking this court to decide now is whether or not Section 191 is applicable at all, then with respect, intervalve doesn't answer that question.
Give me a minute to check my notes, please. This is what the court said in intervalve at paragraph 40. Referral for conciliation is indispensable. It is a precondition to the Labour Court's jurisdiction over unfair dismissal disputes.
Yes, referral to. We agree with that. Referral to in the context of Section 191, and it's indispensable in relation to 191. Not conciliation, referral to conciliation, because conciliation may not happen. Conciliation, I don't know, the conciliator gets sick or the parties don't attend the meeting, 30 days pass and the jurisdictional fact is established. So it's absolutely indispensable that there should be a referral to conciliation if you proceed under 191. If, on the respondent's argument, 191 is incorporated by reason of 111 reference, then of course, intervalve is decisive and a failure to conciliate is the absolute answer. But that begs the question, because the question is Section 191 applicable, or is it just a timing thing from 19111?
Thank you. I understand the applicant's argument. Thank you, Mr. Palama. Thank you, Chief Justice.
Mr. Palama, I was wondering whether one could say that there are two equally plausible interpretations that pull in either direction with regard to the dispute, but you would probably suggest otherwise, if I understand the tenor of your argument, and you would say that the interpretation that you contend for, that 189 creates a substantive right, and sufficient weight must be given to that. Arising out of that, I just have this question which just occurred to me now, so I haven't had a chance to think through it, but I thought I should. 189 refers to the phrase "in terms of" in three different places. It refers to it if a facilitator is appointed in terms of subsection 3 or 4. It refers to it again, let me see.
It will refer to it twice in
sorry.
section 191.
So it's twice there, right? In the first part of, and then finally it's referred to in 189.87B2, which is.
And in 19
Right.
sub 8.
It would seem to me, and I'd just like your view, and probably Mr. Maip will have something to say on that, that what they refer to are really enabling provisions. The facilitator, the power to appoint a facilitator is created in 189.3. And what this does is it simply, in terms of, says a facilitator appointed in terms of that enabling provision. Whereas if one appointed subject to, it has a different meaning.
Yeah.
Because subject to may suggest dependent upon something being fulfilled. Now, your argument is that all that the reference to 191.11 does is that it doesn't create the substantive right, because that's already created, and it's a reference to the time period. Would it have been any different if 191 was a reference to 1915B? Would the argument still be the same?
No, it wouldn't be the same at all. And if in fact the 11 was removed, if it had said a fair reason for the dismissal, the Labour Court would still be a difficulty, but it would then have to be understood in the context if it said in terms of Section 191, because then Section 191 has a process. So yes, it would make a difference if it referred back to the operative section rather than just the timing section, because you're giving 191.11 a whole new role and burden that it doesn't have in its place where it's situated. It creates a whole new process indirectly via that referral, which we submit that an interpretive exercise shouldn't be.
And then finally, to the extent that you contend that we would have to look at the purpose of the Act, and one of those purposes is to provide for a cost-efficient mechanism to resolve disputes,
Yeah.
and the interpretation that the respondents contend for is cumbersome and multi-layered. But even having done so, do we not run the risk of defeating another purpose of the Act, which is to maintain a conceptual difference between conciliation and facilitation? How does one reconcile, as it were, those competing contentions?
Well, you don't have a conceptual difference applicable in 189A 7B little Roman 1 in relation to the strike. So it doesn't say that the one is equivalent to the other. What it says is one substitutes for the other. And we're submitting that reading that same concept, that policy choice of the legislature, following it through into the other leg of the election, doesn't undermine anything within the Act. It's consistent. Conciliation does have its own separate role, but in this highly specialized separate section, which incorporates facilitation and gives rights following a failed facilitation, the rights are different. We submit that provides no reason under the purpose of the Act not to adopt such a meaning.
And then finally, with regard to the major surgery that was suggested, it would seem to me that the effect of the surgery is, it may be major in terms of the number of words it excises, but its effect is quite minimal.
The effect is to give 19111 the same role as has under 191.
Yeah.
So that's the effect.
Thank you.
A convenient time to take the tea adjournment, Ms. Philemon?
Yeah, absolutely, of course.
Right. Until 11.
And we make three sets of submissions. Firstly, we submit to the court that that interpretation is so fundamentally at odds with the language of the section that it could really, with respect, only be achieved by way of a legislative amendment to either section 191 or 189A7 itself. Secondly, we submit to the court that the applicant's interpretation is at odds with what has been referred to in the jurisprudence as a universal norm, that all dismissal disputes that come before the Labour Court must first have been referred to conciliation. And certainly that if this doesn't apply, then one would expect the LRA to say so clearly, which is not the case in the present instance. And thirdly, we submit to the court that all 7 points made in the applicant's heads of argument in support of their interpretation, which were advanced by my learned friend orally, do not operate so as to render the applicant's interpretation the preferred interpretation. In order to set the backdrop for my submissions, it's necessary to say something about Section 189A and Section 191. Section 189A, the court will know, regulates large-scale retrenchments, and it was added to the LRA in 2002. My learned friend says that it introduced two innovations. We, in our respectful submission, say it introduced three main innovations. The first is that it afforded employees, for the first time, a right to strike over retrenchments. The second is that it provided for third-party intervention in the consultation process before notice of termination is issued. And then thirdly, it created a mechanism by which disputes over the procedural fairness of the consultation process could be decided in live time or shortly after the dismissal. This court will know that it's handed down several judgments that deal with Section 189A. Most recently, the Regenesis judgment, the earliest Edcon versus Steenkamp, or Steenkamp versus Edcon. For present purposes, Justices, the CCMA's involvement is of some importance. And it comes about in one of two ways. The first way is if the employer or a union representing the majority of affected employees opt for conciliation when notification of a contemplated retrenchment is issued. So there's a decision, the employer or the majority union says we want facilitation. What then happens is that the CCMA will appoint a facilitator, and this is important, the language is to assist the parties in the consultation process, which the LRA effectively prescribes must run for 60 days. After the elapse of those 60 days, and this court has referred to that 60-day period as a dismissal-free zone, after the elapse of that 60 days, and upon the completion of what might be termed a facilitated consultation process, the employer may then give notice of termination. This is when Section 189A7 then enters the equation. In response to notice of termination, the union or the employees that are affected by the retrenchment, so says the Act, can give notice of strike action. 48 hours notice in the private sector, 7 days notice in the public sector. They can do that without any referral to conciliation, or they can refer a dispute concerning whether there's a fair reason for dismissal to the Labour Court in terms of Section 19111. So you can strike or you can litigate over, in effect, the substantive fairness of the dismissal. That's the facilitation route. If a facilitator is not chosen, then what the Act provides is that the parties must consult for 30 days, whereafter a dispute may be referred to either a bargaining council or the CCMA. And then after the elapse of the period in 64, which is really the 30-day consultation period, the employer may give notice of termination. Now, what is important is to appreciate that when interpreted in that way, then the non-facilitation route and the facilitation route are synchronized in the sense that when you choose facilitation, 60 days. If you don't choose facilitation, it works out to 60 because you must consult for 30. Then you can, and it would typically be the employer who refers a dispute, wait out the 30-day period, and then terminate. So in both instances, it's synchronized from a time period point of view, but it also introduces some commonality, and that is facilitation, a facilitator is appointed, non-facilitation, a CCMA commissioner is appointed. What's important, and I'll come back to this, is when that referral is made after 30 days, it's not a dismissal dispute. What the employer is doing is effectively saying the dispute is our failure to reach an agreement, a mutual interest dispute, and we need the assistance of the CCMA or a bargaining council commissioner who then seeks to broker an agreement very much mirroring what happens in the facilitation context. If that doesn't work, then notice of termination can be issued, and then the parties have precisely the same rights. You can go on strike, or there can be a referral to the Labour Court. Turning then to section 191, you know from subsection 1 that it provides that all dismissal disputes must be referred to conciliation. Subsection 5 deals with what happens if conciliation fails. And in the case of a dismissal for operational requirements where conciliation fails, then the employees are entitled in terms of 5B to refer the dispute to the Labour Court, and that then brings us to 11A, which I'll come to now. But what is important at this juncture is to emphasize the following, that section 1915 is jurisdictional conferring. And if I could ask you please to have regard to page 11 of our heads, paragraph 22, the judgment of Murphy AJ as he then was in SA 5 engineering, the underlined portion at the end of the quote. The reference to section 1915 is important in that such provision operates to confer jurisdiction on the Labour Court only if the Bargaining Council or CCMA Commissioner is certified that the dispute remains unresolved or if 30 days have expired since the referral of the dispute to conciliation in terms of section 1911 and remains unresolved. If I could then deal with the interpretation of 19111, and I'll return to it in dealing with the applicant's 7 points. The applicant's construction of section 19111 is set out in paragraph 30 of our heads of argument. What our learned friends want this court to do is to interpret section 19111 as follows. The referral, in terms of section 5B, are admitted, of a dispute to the Labour Court for adjudication must be made within 90 days after, one deletes the words, the council, or as the case may be, a commissioner has certified that the dispute remains unresolved, and then add the words, the employee or trade union has been served with a notice of termination. So it takes out 5B, it takes out all reference to conciliation, and as if that is not enough, it then adds the words, the employee or trade union has been served with a notice of termination. This, with respect, is more than surgery. It's a rewriting of the section in its entirety. SA Technical, the judgment that was relied upon by the LAC in this matter, makes two important findings. It says at paragraph 10 that the text of subsection Roman numeral 2 is the seat of the controversy in this appeal. On a plain reading, upon the ending of the facilitated process, a party is required to proceed further as prescribed by subsection 19111, which in turn implicates 1915B. The result of these interlocking provisions is that a referral to the Labour Court may be made if the referring party is armed with a certificate of non-resolution of conciliation, conciliation or the 30 days since referral to conciliation has elapsed. And then similarly, if I could ask the court to have particular regard to paragraph 21, where the court begins by saying the approach taken in Bell Equipment to the allusion in section 189A7B Roman numeral 2 to 191 being merely to utilize a time period is in my view unduly strained because the very text resists the gloss placed upon it. And then the court goes on to ask, however, one is driven to ask why the drafters didn't simply say so in a straightforward way, if that was their intention. Then, in relation to the universal norm, if I could ask the court to have particular regard to paragraph 22, where the court says that, but more importantly, the neatness of Bell Equipment's conclusion to rescue the 189A7 process from the superfluous referral to conciliation must compete with the equally neat notion by reference to a single universal norm, i.e., all that comes before the Labour Court about unfair dismissal must pass first through the portal of conciliation. It is appropriate that due weight be accorded to this consideration. Where that norm is not to apply, the statute ought to unambiguously and unequivocally say so. That statement about a universal norm, Justices, is echoed substantially in the paragraphs from this court's judgment in Intervalve that are quoted by the Labour Appeal Court in this matter in its judgment at paragraphs 13 to 14. I turn now to the applicant's 7 points. They are set out in pages 15 to 23 of our heads of argument, and I'm simply going to paraphrase and add to our arguments along the way. Firstly, my learned friend contends and emphasizes that section 189A makes reference to the Labour Court and not the CCMA. That is true. But that section goes on to refer to the Labour Court in terms of section 19111. And as Justice Sutherland put it in SAA Technical, that gives rise to a whole lot of interlocking provisions. It takes you to 1915, 1915 takes you to 191. And we contend that that is the proper interpretation. Secondly, our learned friends contend that because section 189.8, and this is the non-facilitation route, expressly contemplates a referral to the CCMA, this shows that a CCMA referral was deliberately omitted from section 189A7. And as I've sought to explain, we take issue with that because what 189A8 does in providing for a referral to conciliation is to synchronize the time periods and to provide for the involvement of a third party, similar to where there is facilitation. And this referral to conciliation takes place before the dismissal. The dispute that is before the CCMA, the Bargaining Council, is the inability to conclude an agreement. There's an attempt to conclude it. So one cannot, with respect, point to that as being of any, in our submission, particular moment. Then thirdly, the applicants say that because Section 189A7 permits strike action without a referral to the CCMA, the same should apply to labour court litigation. Well, with respect, we take issue with this. What Section 189A7 provides for in relation to a strike is that when, and I must emphasize this, notice of termination, it doesn't have to be dismissal, once notice of termination is given, there can then be a strike on 48 hours notice. Justices, that is a retaliatory strike. Employees who are subject to the retrenchment and their fellow workers who aren't are entitled to oppose that decision to retrench by way of a retaliatory strike by giving only 48 hours notice. The right to strike would be emasculated if a CCMA referral was then required, because if you had to make a referral, that would take 30 days. By that time, the notice period would have run out. By that time, the decision to retrench would have taken effect. There are other instances in the Labour Relations Act where employees are entitled to engage in a retaliatory strike without a referral to conciliation. Where, for example, employees strike in response to an unprotected lockout, that can be done on a retaliatory basis without a referral to conciliation. Where an employer unilaterally amends terms and conditions of employment and it is required to restore the status quo and it doesn't, employees are then entitled to resort to a retaliatory strike without a resort to conciliation. That's the reason why conciliation is not required here. Then, central to my learned friend's argument is that facilitation effectively takes the place of conciliation. I'm going to use much of the remaining time to deal with this and make several points. Firstly, and most fundamentally, a facilitator is called a facilitator in Section 189A3, sub 5, and sub 7, not a conciliator. Secondly, a facilitator and a conciliator, justices, are appointed at a different time. A facilitator, when we're dealing with 8, which applies in this case, is appointed right at the outset when a notice of contemplated retrenchment is given. A conciliator is appointed only after the facilitation process has been completed. The facilitator is off the scene and the employer issues notice of termination, and that generates a dispute. Then the conciliator is appointed. And a facilitator and a conciliator perform different tasks. What does a facilitator do? A facilitator assists the parties in the consultation process. You've seen the authorities in our heads. That person is a chairperson, is a resource, assists them. Whereas what does a conciliator do? Well, a conciliator tries to resolve a dispute. My learned friend in his argument makes a number of fair concessions. He accepts that facilitation and conciliation are, as he puts it, ex lege different. There can be no debate about that. He says, too, that they are conceptually different. There can be no debate about that. But he says they're not practically different. And what he's saying is that once you've gone through a facilitated consultation process, in effect, there's nothing to talk about when it comes to conciliation. And we take absolute issue with that. My learned friend's conceptualization of what happens during the 189A process is that everything works properly, that you consult, the parties engage in a meaningful joint consensus-seeking process, that they act maturely, they act in the best interest of their respective parties, and they get all but nigh to an agreement, but don't quite. So he says, now you go to conciliation, what is there to talk about? But as this court would know, particularly those justices with a labour background, that's not what happens during a 189A consultation process often. Often what happens is a union, for example, might set its face against any retrenchment and doesn't consult properly at all, despite the facilitator being there and trying to get parties to conduct themselves constructively. What the employer does is the employer says, well, what we're going to do is let's dismiss these people. And then we go to conciliation, and at conciliation we try and resolve the dismissal dispute. That quite often happens. Quite often happens. What is important to understand too is that once the legislature afforded workers the right to strike over retrenchments, the 189/A consultation process also has shades of collective bargaining about it. There's a collective bargaining dynamic. The union is entitled to say, no, we're not going to engage in this. If you retrench us, we're going to go on strike. It's not typical consultation as one knows it in the ordinary course. There are those kinds of dynamics. The employer is also entitled to respond to that. But most fundamentally, there could be much to talk about, justices, depending upon what happened or didn't happen during the facilitation process. You can't have this construction that my learned friend uniformly puts forward, that everything would have happened and there'd be nothing to talk about. With respect, that is incorrect. The fifth submission made by our learned friends is that the interpretation that conciliation must be made, or there must be a referral, emasculates the right to refer the matter to the Labour Court and frustrates the object of ensuring expeditious dispute resolution. This is a very difficult submission to understand. I mean, what you have here in this case is that the notion of conciliation is inconvenient for these employees because they didn't do anything for 5 months and then they referred a dispute to the Labour Court. But the idea that employees and organised labour would come to this court and say, we don't want conciliation, that doesn't serve the purpose of this act. It frustrates the expeditious resolution of disputes. With respect, is quite startling, because what the LAC is saying is that after facilitation and the issuing of a notice, then you must go to conciliation. That adds only 30 days to the determination of a dispute about the substantive fairness of retrenchment, which of today takes 2, maybe 3 years to come to trial in the Labour Court. How does this defeat the expeditious resolution of a labour dispute? It's an extraordinary submission. One would have thought that employees and organised labour would say, if you can give us another shot at resolving this when the dynamic has changed, because now you've dismissed the employees and now you know you potentially face this litigation, perhaps that softens you up, perhaps that drives us to a resolution. One would have thought that they would jump at that opportunity. Then my learned friend in his heads relies on the regulations. I think he's accepted that that cannot be used for the purpose of interpretation, and also he refers to Edcon, which I think he accepts too, was an obiter comment as found in SAA Technical. Chief Justice, those are my submissions.
Mr. Maybeck?
Mr. Maybeck, if you could just help me again with the 2 subsections, that is 189(7) and 8.
Yes.
I just want to get a clear understanding. Under 7, there's a facilitator, and nothing can be done until the period of 60 days has lapsed.
Yes.
The employer cannot issue a notice of termination.
Correct.
The workers cannot issue a notice to strike.
Correct, Justice.
Under 8, there is no facility.
Yes.
What happens?
So under 8,
Yes.
I'm sorry if I'm interrupting you.
Yes, yes.
Can I go ahead?
Yes.
Under 8, you get to exactly the same situation. Because, firstly, perhaps I can just go back a moment. The reason that 189A got onto the statute books is there was a concern by organised labour as to decisions that were coming out of the courts. And so they wanted the right to strike. So this system is designed. Justice, you've perfectly correctly described the facilitation route. But it would be peculiar if you had two completely different provisions, facilitation versus non-facilitation. Because remember, they both get to the right to strike, and they both get potentially to a referral of a dispute to the labour court. So they actually are synchronized, because what they provide for is the non-facilitation route. The employer hasn't asked for it, and there's no majority union that's requested it. So how does the legislature synchronize? Legislature says, all right, take a shot at consultation for 30 days. Then a dispute can be referred to the CCMA or the Bargaining Council. And this section 64, and that's unfortunate because it cross-refers to a strike section, but those time periods must run out. Now that's a 30-day period. That's the conciliation period. So you consult for 30 days, you refer a dispute, you wait out 30 days. What's happening now is the same 60-day dismissal zone is created. 30 days consultation, 30 days waiting out the conciliation period. And they synchronized in the sense that there's third-party intervention, at least in respect of the other 30 days. Once that 60-day dismissal-free zone is run out, then in both instances, there can be a resort on notice to strike, or there can be a referral to the labour court. What is important to appreciate is that dispute that is referred. Those are disputes that are referred by the employer, because if the employer doesn't take the initiative and refer a dispute, well, then there's nothing that can be done. So the employer will immediately upon the 30 days after it's elapsed refer a dispute. What is that dispute? That's not a dismissal dispute. What the employer is effectively saying is, we haven't reached an agreement. We've got 60 days. 30 days have gone. We haven't reached an agreement. That is a mutual interest dispute involving the failure to reach an agreement. It's not a dismissal dispute. So that's how they are synchronized. And they must be, because they lead to the same outcome.
So that's basically the dispute concerning the proposed retrenchment.
Yes.
And if they can't agree, and the 60 days has now lapsed, then the employer can then issue the notice
Yes.
to terminate.
In both instances, it amounts to the same. Yes.
Now, under the reference to section 191.11,
Yes.
why did the legislature not just refer to basically section 191? Because we know the section 191 deals with the dismissals, and if the intention is to refer everything to
Well,
conciliation.
I think as my learned friend has really submitted, I mean, this is an awkward drafting on both sides of the fence. But it seems in our respectful submission, the preferred interpretation is that ultimately when you have regard to 191.11, it sets in train a whole lot of interlocking provisions. It takes you back to 5, which is a jurisdictional section, and it takes you back to 1. Guided also by, it seems, a key principle in the LRA, and that is, as a general rule, there must be conciliation. And if that is to be removed, the Act must say so clearly and unambiguously, and that doesn't occur here. The interpretation that we contend for is also supported with respect, as I've explained, by the object of the resolution of disputes and the expeditious resolution of disputes, because here parties get to resolve the dismissal dispute 30 days after the dismissal. If they don't do that, they take 3 years before they get to the Labour Court. It actually operates to serve the purpose of the expeditious resolution of labour disputes.
Mr. Maybeck, thank you, CJ.
Mr. Maybeck? Mr. Maybeck?
Yes, Justice.
The applicant says that it was a deliberate choice by the legislature to use facilitation in these circumstances. For instance, concerning operational requirements for employees over 50.
Yes.
So he says that the choice by the employer was to substitute conciliation.
Sorry?
It was to substitute.
Yes.
I'm
I understand, yes.
Yes, yes. It was to substitute a conciliation. Why can't we make that conclusion?
Well, because with respect, it would be wrong at various different levels. And that is, firstly, a facilitator, as I've said, under the LRA, is called a facilitator, not a conciliator. It's a specific sui generis appointment, point number one. Secondly,
Interrupt you, Mr. Maybeck? I'm debating
Yeah.
with you, you know.
I appreciate that.
So forgive me if I interrupt.
Please go ahead, Justice.
Yes. Yes, even if they are not the same, or the role is not the same, but are similar. He says that that was a deliberate decision by the legislature to use facilitation in this instance. And if you bear in mind the fact that the Labour Relations Act is structured in such a way that certain schedules and certain departments or certain sections deal with different topics.
Yes.
So why should we not accept that in the topic concerning dismissal for operational requirements of employees over 50?
I
The
think,
legislature decided to do away with conciliation, but
I
use
think perhaps,
facilitation
I think
for dismissal.
most fundamentally, and I'm sorry if I'm repeating myself, but I think most fundamentally, it's because facilitation doesn't happen, Justice Chiki, when there's an unfair or a dismissal dispute. What facilitation does is this. When Section 189A doesn't apply, the parties come together and they consult. Because this is large scale, and because the legislature has an interest in trying to save jobs, it provides for a facilitator who is there to assist the parties. And they consult for these 60 days. There's no consultation, there's no dispute about an unfair dismissal. When the 60 days is completed, the facilitator goes off. The employer is then entitled to issue notice of termination. That may or may not give rise to a dispute. If it does give rise to a dispute, it might give rise to various different disputes. It could give rise to a mutual interest dispute and a strike. It could give rise to procedural unfairness dispute and a 189A13 application, or it could give rise to a dispute about the substantive fairness of the dismissal. The facilitator is now off the scene. Now, at a different time, different causa, what is required is the conciliation of that dispute. So most fundamentally, let me leave aside the appointment of the people, but it's at a totally different time and it deals with different things.
I understand the way they would work if
Yes.
both of them. If we accept your submission that both of them are relevant, I'm still trying to understand the submission that was made by the applicant that it was the legislature who decided to do away with conciliation.
We would take issue with that.
And then what also bothers me is the reference to labor court. And to then decide not to when it says that in terms of section 191 to choose not to rely on 5, section 1915, but to rely on 191.11, that also talks about the labor court.
Yes, and I've addressed your ladyship on that. I mean, I accept entirely that as the Labour Appeal Court put it in SAA Technical, it is awkward. But we advance the submission and the finding in SAA Technical that what that does, reference to that section, sets in train a whole lot of interlocking statutory provisions and in effect provides for conciliation. We're not suggesting for a moment that this is a one-horse race and it's an easy interpretive exercise. Our submission is simply that the matter should be decided as the Labour Appeal Court did in SAA Technical, on balance.
Thank you. One of the things that bothered me when I was looking at this case is if we adopt your reasoning and we reach that conclusion, is there no danger that employees will decide that it's better to go on a strike action? Because in a strike action, once you get the notice and the time has elapsed, you then go for a strike instead of going for the litigation route.
No,
The other one is readily available. The other one concerns a process where the employees themselves are in a situation where they are being dismissed.
yes, well, I think the point is, Justice Chiki, that in both instances where you go on strike or you refer to the Labour Court, there would be notice of termination. Whether you introduce conciliation or not, I don't think it's going to lead to more strike action, because the employees are given notice of termination. They are dismissed. Now what do? They either go on strike or they refer dispute to the Labour Court. Notice of termination is running. What we are suggesting is that it's in their best interests that once they're given notice of termination and they declare dispute and they want to go to the Labour Court, they first go through the portal of conciliation, because that dispute could be resolved there. That's in their best interest. They don't have to wait for 3 years before the matter's heard in the Labour Court. That's all we're contending for.
Thank you, Mr. Yep.
Mr. Myburg, I think in putting something to your opponent for comment, I may have misread the subsection 8. So I just want to get clarity on this and on its implications. When subsection 8b says once the periods mentioned in 64(1)A have elapsed, you say if you go back to 64(1)A, the dispute that is there contemplated is a pre-dismissal dispute.
Yes, John.
Because in the nature of things, that period has to have elapsed before the employer can give a notice of termination.
That's correct.
Would you call that basically a dispute over an interests dispute at that stage?
Yes, if I may, and perhaps I could provide the court with the reference, but you will be familiar with the fact that in Edcon, the LAC overruled an earlier judgment in De Beers. And what had happened in De Beers is they didn't appoint a facilitator. After the 30 days, the employer terminated. And I sought to argue before the LAC that there actually wasn't a dispute. It didn't have to be referred to conciliation. And what Justice Davis found there is it's the dispute, the conceptualization of the dispute is actually the failure of the parties to reach an agreement. So I'm sorry, that's a bit of a long way around answering you. But it is a mutual interest dispute. It's not a dismissal dispute. It's a properly conceptualized. It's a failure to reach agreement.
But all right, and then you say once that has happened and the parties have failed in the 30-day consultation period under subsection 8 to come to terms, one of them then could be the employer or the employees refer the 64(1)A dispute, if I can call it that,
Yes.
the interests dispute, and let us say that 30-day conciliation period fails. Then you say the parties under subsection 8 are exactly similarly placed to subsection 7.
Yes.
There can either be an immediate right to strike, once there's been notice of termination,
Yes.
there can be an immediate right to strike, or there can be a referral to the Labour Court in terms of section 191.11, which you interpret to incorporate the 191.5.
Yes, the language there is the same in both sections, yes.
So under subsection 8, there would have to be two referrals to the CCMA. First,
Yes.
the pre-dismissal dispute, and afterwards the dismissal dispute.
Correct. And so if
Now-
I may, I'm sorry to interrupt.
No, if you
Yes, and I tried to touch on that when outlining the sections. I mean, I understood the concern that you had. What is important with respect to appreciate is that we're dealing with different disputes. I mean, just like when you get to facilitation, you can't say when the facilitation process is ended, then it's the same as a dismissal dispute, because the dismissal hasn't happened. The same applies here, Justice Rogers, and that is the conceptualization of the dispute is important, the initial one. It is effectively a mutual interest dispute, the failure to reach agreement. The third party then intervenes in a way that might be broadly analogous to facilitation to try and get the parties to an agreement.
so there you're happy to see a close correlation between conciliation
Well,
and
it's
facilitation?
different, but I mean, there's an attempt. If the dispute is the failure to reach an agreement, then it seems to follow that there's an attempt to broker one. The point that I wanted to make is that that is different from the dismissal. So if that fails, then the employer, like a facilitation fails, and there's no agreement, then the employer can give notice. That gives rise to a different dispute. And then, in reaction to that, there can be a strike or there can be a referral. The short answer is yes, my submission is that there would then have to be another referral, but it deals with a different dispute.
So, just to understand this, I appreciate that there might be a range of types of disputes that might cause the parties after 30 days of consultation without facilitation to have failed to come to terms. But in essence, if one of them wants to go to conciliation, will it not essentially be because the employer maintains that there are fair reasons to retrench and the employees are disputing that? That's essentially, that at least most commonly will be the 64.1a dispute.
Well, the 64.1a dispute, remember, is halfway through the 60-day period.
Yes,
But I think,
but they'll only go to conciliation because one party thinks it's fair to proceed with retrenchment and the other side think not. The conciliation may resolve that just as another 30 days of
Yes, absolutely.
facilitation might have resolved it. But ultimately, there wouldn't be a need to refer to conciliation or to have a longer period of facilitation unless the employer was maintaining that there are fair reasons to retrench and the employees were saying otherwise.
unless the parties couldn't reach an agreement. When parties in a retrenchment context don't enter into an agreement, it doesn't necessarily mean there's a dispute. And Justice Rogers, for someone that has been exposed to lots of these things, retrenchment consultations fall apart for various different reasons, and the dynamics that are involved in retrenchment consultations, particularly with the spectre of a potential strike looming, are very difficult and complicated. It's not always as simple to say, well, this is one size that fits all. So, for example, as I've suggested, a union could set itself against retrenchments. And you don't get anywhere in the consultation process. You can't reach agreement. You can't get anywhere. And so what the employer does is it says, well, then we're going to retrench you. Let's see what happens at conciliation. That's an ideal place to resolve that dispute because now the dynamics are different.
Now, I understand why an extra 30 days in the subsection 8 scenario may be useful, but the only reason why it's needed is because the employer on the one hand and the workers on the other are at loggerheads as to whether there is
Yes.
a fair reason to dispute, to retrench. And if that 30 days conciliation is unsuccessful, then you're saying the employer then can proceed to dismiss, and the employees must then go to the CCMA again to say, well, previously we were claiming in advance that there are no fair reasons to retrench. Now we're claiming ex post facto that there were no fair reasons to retrench.
Well, those are different disputes, Justice Rogers, and the classification of a dispute in labour law is critical.
But now, if I accept that there are different disputes, and so I presume you would say even in the subsection 8 situation, when 191.11 refers back to section 191.5, you have to look at what dispute you're talking about. If you were talking about the pre-dismissal dispute, that doesn't get you in under 191.11 for the dismissal dispute. You have to have gone through the hoops again for the dismissal dispute.
Right.
Now, that same distinction, of course, holds true for the right to strike. And yet, under 64, there's a right to strike, not over the original mutual interest dispute.
Yes.
There's a right to strike over the dismissal
dismissal.
dispute, despite the fact that the dismissal dispute never went to conciliation.
Yes.
Now, you would accept that ordinarily there would need to be the very dispute that is the subject of the strike has to have been conciliated.
Absolutely.
Now, the lawmaker has dispensed with the need for conciliation in respect of that very dispute in regard to the right to strike. What is the legislative logic of compelling? So we're already in the situation where we know that the lawmaker has departed from the requirement of conciliation when the remedy to address the dismissal dispute is a strike. Apart from the universal norm, which of course the circular argument, because what we're debating is what is the effect of 189A. What is the logic for saying that the lawmaker could quite properly dispense with that in regard to strike, but hasn't done so in regard to, if Labour prefers to go the litigation route? And I think this might have been the subject of my Sister Tiki's question, which is that if you're going to make the workers go through more hoops in order to pursue the labour court route, well, perhaps you're just going to encourage strikes because they don't have to go through the hoops.
They're only going to get to the labour court in 3 years, Justice Rogers. This is to help them if it goes to conciliation. But you ask about the legal logic about it not providing for conciliation in the case of a strike. The legal logic is that this is a retaliatory strike. So the whole purpose of these amendments, one of the main innovations, as you know, is that workers were afforded a right to strike in retaliation to the retrenchment.
But aren't all strikes a retaliation to something, and yet ordinarily there has to be 30 days?
But this is to give them power. You're undermining the right to strike. Yes, absolutely. So if you have a wage dispute and you have to refer a dispute and you have to wait out 30 days, it doesn't undermine the right to strike. Here, the power is greater to oppose a retrenchment when you are entitled to strike in retaliation without going for 30 days. If there was the 30-day consultation or conciliation, I beg your pardon, window, that notice period would have run out, those retrenched workers would have gone. And also, you would be dealing with it not on the spur of the moment. So the design is to give the workers power, more power, so as to protect themselves against the dismissal by not providing for conciliation. The same doesn't apply when you're dealing with the dispute of right. Now the workers are saying, well, we're not going to go on strike. We want to go to the labour court. We want to challenge the substantive fairness of our dismissal. What legal logic, leaving aside the wording, would say that mustn't go to conciliation because conciliation assists them to resolve that dispute? The employer might very well say, this facilitation didn't go very well. I'm not sure if this was a fair retrenchment. I've pulled the trigger. I'm now facing labour litigation in 3 years' time. If I lose and these employees are retrospectively reinstated, I'm going to lose my business. So therefore, I'm going to enter into a settlement. So there is, with respect, a legal or legislative logic to not providing for conciliation when it comes to the exercise of power, interests and mutual interest disputes, and on the other hand, typical rights disputes.
Thank you, Mr. Myberg. I just want to touch on the point you made with regard to Section 191, subsection 5B, being a jurisdiction assigning provision, and you refer to SA5 engineering. With regard to the architecture then of Section 191 in its entirety, would you then agree that when one gets to 191.11, the question of jurisdiction is really not on the table because it's been assigned already in terms of 5B?
Well,
And 191.11 really
It
speak
depend-
of the timeline. I just want to get some clarity.
yes, no, I think it depends, Justice, on one's entry into this. I mean, if you look at it from 1 onwards, you might form one view. But Section 189A7 takes you directly.
Sorry, I'm speaking about 191 for now.
Yes, so Section 189A7 takes you directly to 191.11.
Yes,
Refers to that.
we'll get there, Mr. Myberg.
Yeah.
I just want to understand that you accept that 191.11 is not a jurisdiction assigning provision because jurisdiction has been assigned already under 191.5B.
Well, I'm not sure with respect, but I do,
That's the impact of SA5 engineering, not so. It says expressly
yes.
that they're interrelated, but jurisdiction is assigned in terms of 191.
Yeah, I understand, yes.
That's the only point I want to
Yes.
make there. So when one looks at 189.7,
189A7.
A7B2,
Yes.
is that a jurisdiction assigning provision in your view?
Well, that must be done, yes.
Okay, so if that is a jurisdiction assigning provision, then we have jurisdiction arising in terms of 191.5B, and then in respect of a process of facilitation, there is jurisdiction arising in terms of 189A7B2.
Yes.
Right. So if the reference in B2 is that it's a jurisdiction assigning provision to be, well, in terms, it's assigning jurisdiction to the labor court in terms of 191.11, correct?
Yes,
So jurisdiction has been dealt with already. This assigns jurisdiction.
it assigns a jurisdiction in terms of 191.11. And then we get the
Let's
awkwardness.
go to 191.11. So if it assigns it in terms of 191.11, and we then travel to 191.11, when we arrive at 191.11, jurisdiction has already been assigned, correct?
Yes.
Then the only relevance of 191.11 is the timeline. Because if 191.11 must take us back to 191.5B, then it doesn't make sense, because you can't have a jurisdiction assigning provision that revolves and takes you back to a jurisdiction assigning provision that you must then satisfy.
Yes, I appreciate that.
So that's the difficulty I
Yes,
have.
and I mean, that is just as you put your finger on the awkwardness of these various cross-references. The Labour Appeal Court dealt with that in the passages that I've read to you. In SAA Technical, I accept that a different view may be taken. But when you say that the only relevance then of 191.11 is time, even if it was time, my learned friends want the section to be reread in a different way, because if I ask you to perhaps go back to paragraph 30 of our heads, so they want to read it, as you see at paragraph 30, to read the referral of a dispute to the Labour Court for adjudication must be made within 90 days, time, but then of what? They want the words to be added, the employee or trade union has been served with a notice of termination. That's a whole rewriting of that section, and it shows up really the awkwardness. So even if you see it only as time, major surgery is required on that construction.
But Mr. Myberg, then equally on your construction, significant surgery is also required. Because how would you then, if you're saying that we have a jurisdiction assigning provision, but you have to go back and establish jurisdiction, because that's the import of your argument.
Yes.
Then you have to actually substantially excise jurisdiction from 189A7B2, which is much more drastic surgery than simply tampering with the timeline. Because now what you're actually suggesting is that the jurisdiction that is assigned must be taken away, because you have to go back and establish jurisdiction under 191(5)(b). And that's a much more
I appreciate,
radical rearrangement of the scheme of the Act, not so.
if I could just take you to, and I appreciate the question, and I do accept that this can be interpreted in various different ways. But perhaps I could just ask you just reflect on paragraph 10 of the LAC's judgment in SAA Technical. And that is that the text of paragraph Roman numeral 2 is the seat of the controversy. On a plain reading, upon the end of the facilitated process, a party is required to proceed further as prescribed by section 19111, which in turn implicates 1915B. So you see how the LAC adopted a different interpretation and read it backwards effectively. The result of these interlocking provisions is that a referral to the Labour Court may be made if the referring party is armed with a certificate of non-resolution or conciliation or the 30 days since the referral has lapsed. So your Lordship proposes or propounds a sort of forward-looking interpretation from 1 to 11. Here, the LAC enters at 11 and looks backwards. That's the construction in that judgment.
Sure, the only point I make is that as a matter of substance, and jurisdiction is, I mean, on a hierarchy, much more significant
Yes,
than in
I appreciate
some
that.
procedural requirement. And if we have two jurisdiction assigning provisions here, each one of them activated by an objective fact, a different objective fact. The objective fact under 191 would be failure to conciliate the dispute, correct? And the objective fact under 189 would be the elapsing of 60 days. So in both cases, there's a separate objective fact that triggers the jurisdiction.
Yes.
And once the jurisdiction is triggered, then that's it. I can't remember the judgment, but this court has said, well, you either have jurisdiction or you don't. There's no middle way.
Yes.
And so if the interpretation of 189, as you've accepted, is a jurisdiction assigning provision, then jurisdiction is assigned. And that should be the end of the matter.
Well,
With regard
jurisdiction,
to the
the
jurisdiction of the
LAC
Labour
found-
Court, whatever else follows would be procedural or ancillary.
the LAC appears to have found that the jurisdictional conferring provision is 19111. That's the point of entry. And then there are these interlocking provisions that take one back.
That may be so, but if we read 19111, it arrives really on the scene after jurisdiction has been assigned in terms of 191(5)(b. And that's the effect of SA5 engineering, not so.
Certainly. But I've made the submission, though, that section takes one back to 5B, and that's the way that the Labour Court in SAA Technical construed it.
Thank you, Mr. Mayor.
Thank you very much, Mr.
So, Chief Justice, may I just mention one other thing? I did mention to you in chambers that yesterday afternoon we did email to the court certain materials that we came across, and we did this by agreement. The materials are a draft Labour Relations Bill drafted by NEDLAC that proposes amendments to, amongst others, the very section that we're dealing with now, together with a report of NEDLAC and a letter showing that the report and the bill went to the minister. Neither of us have relied upon them. We thought we would rather be criticised for bringing something to the attention of the court that was irrelevant than potentially being accused of hiding anything from the court. So we have 11 packs, which we can give to your associates perhaps after the hearing, or we could hand them up now. It has been sent electronically.
All right. You're free to hand them in now if you wish, for what that may be worth.
Thank you. So we would ask, in conclusion then, that the appeal be dismissed. We don't seek any costs if we were successful.
Thank you, Mr. Maiba. Any reply, Mr. Pilima?
The two arguments have been quite extensively debated, and there are just two features I just want to mention in reply. The first is to go back to the questions that were raised in relation to Section 189, capital A, 8, in respect of its interpretation and how that may impact on 7. What emerges quite clearly from a learned friend's argument is that in practice, it seems, an employer would be keen, if it's intent on terminating as speedily as possible, to refer the dispute immediately after the first 30 days have passed, as it has the right to do under the second part of Section 18978. That referral has to happen because the need for such a referral hasn't been exempted as it is in the case of facilitation covered by subsection 7. So once it's referred immediately, there's then a conciliation. And with respect, what's going to happen there is going to be a conciliation about a potentially unfair dismissal. And if that conciliation doesn't achieve its object of settling the dispute within 30 days, and the dismissal takes effect, then the logic is, if Section 19111, in terms of Section 19111, which applies identically, the wording is identical in both sections, is that there has to be another second conciliation. Now, the question is, which doesn't have to happen in a strike. So the question is it the policy implicit in this legislation that you don't have to have two conciliations, one immediately after the other, and that it would be absurd to do so? If the answer to that is yes, which we submitted must be, then the same logic with respect applies in respect of 189 capital A 7B little Roman 2. So it does actually provide quite a strong guide to the interpretation of the section that we're engaged with today. The second point I just want to make in conclusion is that my learned friend spoke about the portal of conciliation. There must be conciliation. Well, there doesn't have to be conciliation, with all due respect. What there has to be is a referral to conciliation. Conciliation may or may not take place because the jurisdiction is established under 1915 by a referral to jurisdiction, a referral to conciliation, followed by either a failed conciliation or the passage of 30 days. So the key is the referral to conciliation, not the conciliation itself. And then if that referral occurs, one or two things happen, and that then leads to the jurisdiction question. So conciliation is not absolutely essential for jurisdiction, and to say every unfair dispute has to go through the portal of conciliation is overstating it. It has to go through generally has to go through a process where conciliation would lead to a 195B, but we say on a proper interpretation of the way in which facilitation works, it's excluded in this context. So we submit that the arguments we presented in relation to the interpretation should be accepted, that the interpretation we advance finds favour with the court, and we would ask that the application for condonation be granted, that the application for leave to appeal be granted, and that the appeal is upheld, setting aside the judgment and order of the Labour Appeal Court and reinstating and restoring the finding of the Labour Court, which found that it had jurisdiction in the matter. As I indicated earlier, no costs are sought in the application.
No more questions for you, Mr.
As the court please.
Right. Thank you very much, gentlemen. The judgment is reserved.